All rise. The International Court of Justice is now in session. President Owada and the Honorable Judges Simma and Greenwood presiding.
Please be seated.
The case before the court is the case concerning the Frost files. The parties are applicant, the State of Estonia versus the respondent, the Federal Republic of Risland. The applicant and the respondent are each allocated 45 minutes to present their pleadings.
This afternoon, the court is going to hear the oral pleadings of the parties in the case concerning the differences between the State of Estonia as applicant and the Federal Republic of Risland as respondent concerning the Frost files. The time allocated to the parties will be 45 minutes each, which will include the presentations by all agents of the parties and any rebuttal and sur-rebuttal. I invite the agents of the applicant state, the State of Estonia, to present their pleadings.
President Owada, Honorable Judges Greenwood and Simma, may it please the court. It is my great pleasure to appear before this high court on behalf of the applicant, the State of Estonia. I will present submissions number 1 regarding evidence and Risland's communication surveillance programs, and 2 regarding the seizure and forfeiture of the VOR station and the arrest of its employees. My co-agent, Belen Ibanez, will be presenting submissions 3 regarding Joseph Kafker's detention and 4 regarding the cyber attacks against the Ames Post and Chester and Walsingham. We will each allocate 21 minutes for presentations, and we reserve 3 minutes for rebuttal. As the facts of the case are in the record, I request permission to proceed with our first submission. Thank you. Your Excellencies, Estonia's first submission is that the documents published on the website of the Ames Post are admissible as evidence, and that Risland's digital surveillance programs violate international law. As for the first issue, the documents published on the website of the Ames Post are admissible because there are no applicable rule of exclusion before this court. As recognized in the Island of Palma's case, international tribunals regarding evidentiary matters are bound by their own procedural law and the special agreement submitted by the parties. In this case, the statute of the court contains no rules regarding the admissibility of evidence. In fact, Article 52 of the statute establishes that evidence must be presented within the time limits specified by the court.
Counsel, could you, you mentioned the rules, but could you say a word about the practice of the court, let's say the more recent practice of the court with regard to the admission of evidence?
Your Excellency, with regard to the court's practice, dating back to the first case decided by the court, namely the Corfu Channel, the courts admitted evidence obtained in violation of international law. Moreover, in the Nicaragua case of 1986, the court stated that within the limits of the statute and the rules of the court, it is free to assess the weight of all pieces of evidence submitted by the parties. And moreover, in the recent Timor-Leste v. Australia proceedings, the court did not analyze admissibility of evidence as may be argued by the respondent.
There was one case in the middle, a bit less recent than Timor-Leste, but still pretty recent. in which the question also arose in a slightly different context. And I just wonder whether you know what happened there. I'm referring to the genocide case decided in 2007.
Of course, in that case, the court refused to order evidence that was considered by the state to be confidential. However, that case did not refer to evidence that had been already published, such as the Frost files in this case, and therefore cannot assist the respondent on that matter. Moving on to the next issue, Estonia submits that by conducting its Verisma program, Riesland violated the human rights of Estonia's nationals, and that by conducting its Carmen program, Riesland violated Estonia's territorial integrity, as well as Article 105 of the Charter of the United Nations. With regard to the Verisma program, Estonia submits that it has standing to bring the claim that Riesland is obliged towards Estonia's nationals under the International Covenant on Civil and Political Rights, and that Riesland has violated Article 17 of the ICCPR, protecting the right to privacy. As for the first issue, Estonia is entitled to exercise diplomatic protection. First, because the affected individuals are nationals of the Estonian state, and second, because the local remedies rule does not apply in the absence of a relevant connection between the affected individuals and the respondent state, as recognized by the International Law Commission's draft articles on diplomatic protection of 2006 in Article 15.1c. With regard to Riesland's obligations owed to Estonia's nationals under the ICCPR, Estonia submits that by conducting the Verisma program, Riesland exercised jurisdiction over the communications of Estonia's nationals that were intercepted. Article 2.1 of the ICCPR establishes that state parties must respect and ensure the rights established in the Covenant to all individuals within the territory and jurisdiction of the state. This very court, in cases such as armed activities on the territory of the Congo and the advisory opinion on the construction of the wall, interpreted this article as not requiring the two elements conjunctively to apply, therefore recognizing the extraterritorial application of the ICCPR.
Yes, Counsel, that's very interesting, but those were cases in which the territory in question had been occupied by the respondent state in one case and by the state whose conduct was under consideration in the advisory opinion. Are you really exercising jurisdiction over somebody just because you listen to their conversation?
Of course, the differences between those cases and this case are evident. In this case, Riesland installed a recording pod on a submarine cable transmitting the electronic communications of Estonia's nationals, and according to the High Commissioner for Human Rights 2014 report on the right to privacy on the digital age, where states intercept or interfere with digital communications infrastructure wherever found, they are bound under the Covenant, and therefore, by affecting the communications of Estonia's nationals, Riesland did indeed exercise jurisdiction over this data and is bound.
We're of course not bound by the High Commissioner's view, interesting as it is. What about the decision of the European Court of Human Rights in the Bankovic case about the extent of jurisdiction?
Of course, Your Excellency, the Bankovic case would not assist the applicant on that matter, but the same tribunal, the European Court of Human Rights, in the Liberty and Others case, recognized that the UK was bound to respect the privacy of individuals whose privacy the UK had been affecting, even though the individuals were not located within the territory of the United Kingdom. And moreover, the test set forth by the High Commissioner for Human Rights has been endorsed by special rapporteurs on freedom of expression and counterterrorism and human rights. And moreover, the Human Rights Committee, in its concluding observations on the report of the United States of 2014, also warned against the exercise of extraterritorial surveillance. The United Nations General Assembly, as well in resolutions 68/167 and 69/166, warned against the effect that extraterritorial surveillance has on human rights.
So is it your submission then that any espionage, any interception of communications is invariably a violation of the right to privacy?
No, Your Excellency. With regard to that question, the Human Rights Committee, in the case of Van Hals versus the Netherlands, established that measures that interfere with privacy must be prescribed by law, necessary to achieve a legitimate aim, and proportionate, only if a surveillance measure meets these three requirements, it can be deemed lawful in the terms of Article 17 of the ICCPR. And with regard to legality, the Human Rights Committee, in General Comment number 16 on the right to privacy, stated that legislation authorizing surveillance measures must specify in detail the precise circumstances in which interferences may be permitted. In this case, Friesland's Secret Surveillance Bureau Act of 1967 authorizes the Bureau to acquire, and I quote, any information located or emanating from outside Friesland's territory, end of quote. This does not provide a clear framework in which surveillance activities are exercised.
Of course, a general comment of the Human Rights Committee is not more than a polite suggestion, is it?
No, of course.
What kind of bindingness or authority would you grant it?
First, the opinion of the Human Rights Committee can be taken into account by this court as a subsidiary means for the determination of the rules of law in terms of Article 38(1)d of the statute, and moreover, this court in the Diallo case, paragraph 66, stated that the Human Rights Committee, as the interpreter of the ICCPR established by the very treaty, is to be afforded great weight in its interpretations. With regard to necessity, Special Rapporteur on Freedom of Expression, Frank LaRue, stated that surveillance measures must be strictly and demonstrably necessary to achieve a legitimate aim. Even though Estonia considers or recognizes that fighting terrorism may be a legitimate aim, former Special Rapporteur on Counterterrorism and Human Rights, Martin Skinin, in his 2009 report, said that terrorism is not a trump card which automatically justifies any interferences with privacy. And in this case, respondent has failed to demonstrate the necessity of its Verismo program. Lastly, with regard to proportionality, surveillance over all persons and all data with no objective criteria of differentiation is arbitrary. The Court of Justice of the European Union, in its 2014 Digital Rights Ireland ruling, as well as the European Court of Human Rights in the Sakharov v. Russia and the Szabo v. Hungary cases of 2015 and 2016, stated that undiscriminated retention of communications data violates the right to privacy.
What value should the International Court of Justice, our court, give to findings of regional courts or regional human rights courts?
First, judicial decisions such as those taken by regional tribunals can be taken into account in the words of Article 38(1)d of the statute, but moreover, and coming back to the Diallo case, which I previously cited, in paragraph 68, this court recognized that the findings of other tribunals can be afforded great weight as well when they interpret provisions that are close in substance to the ones being analyzed.
It's a matter of can. We can give it some weight or not. So we are free. If we don't want, we...
No, of course, but Estonia's contention is that these rulings are of great relevance because they analyze surveillance programs such as the Verismo implemented by Friesland, and this court has no precedent regarding these types of activities.
I want to pursue the same point a bit further. You have referred to a number of precedents, either judicial or quasi-judicial or non-judicial. You have referred to the judgment of the International Court of Justice, you have referred to the judgment of the European Court of Justice, you have referred to the European Court of Human Rights. You have also referred to the conclusion of the Human Rights Committee. Now, do you make any difference in terms of the legal values, not necessarily binding force, which is a different matter, but in terms of your assessment? Do you make any distinction between these different pronouncements in accordance with the nature of the body, or are you really using those precedents in order to justify the points that you are making? I just want to know your position on that.
Of course, judicial decisions should be afforded greater weight than the findings of the special rapporteurs. However, all of these, in Estonia's contention, should be taken into account because they analyze surveillance programs and activities that are very similar to those being implemented by Friesland. And with regard to the Carmen program, Estonia submits that by conducting these activities, Friesland has violated the territorial integrity of Estonia. Respondent, in its written submissions, has accepted the rule of international law that when a state sends spies to the territory of another without the consent of the host state, it violates the territorial integrity of the state. And in this case, Estonia never consented to the entry of Margaret Mayer and the other bureau employees who worked at the VOR station. Finally, with regard to Article 105 of the Charter of the UN, this article establishes privileges and immunities to representatives of the United Nations member states, and in this case, as stated in paragraph 26 of the Compromis, Rusland has spied on Estonia's ambassador to the UN, David Cornwell. This constitutes a clear violation of Article 105 of the Charter of the UN. Moving on to Estonia.
You spoke about the consent of the Estonia in relation with Margaret Mayer and other officials. Are you talking about the consent in general of their presence, or the consent of a particular function that they are performing, the particular activities that you are referring to?
I refer to the consent for the activities that they are performing. Indeed, Estonia consented to the entry of Mayer and the other employees as part of the television broadcasting channel, but not as agents collecting intelligence for the state of Rusland. And moving on to our second submission, Estonia submits that the seizure and forfeiture of the VOR station and the arrest of its employees were in accordance with the Broadcasting Treaty and with international law in general. First, regarding the Broadcasting Treaty, this treaty, in Article 36, provides that the immunities established therein cease to have effect if the station stops performing the functions as envisaged in the treaty. As Article 31 of the Vienna Convention on the Law of Treaty provides, treaty terms must be interpreted in their ordinary meaning and in good faith and in accordance with the treaty's context and object and purpose. And this court, in cases such as the asylum case, rights of nationals of the United States in Morocco, has interpreted preambles of treaties as expressing their object and purpose. In this case, the preamble to the Broadcasting Treaty expresses the two nations' desire to fortify their friendship and to strengthen understanding and cooperation. Spying against Estonian nationals under the disguise of television programs is an unfriendly act clearly contrary to the functions envisaged in the treaty, and therefore Estonia submits that since the Carmen program began in 1992, the privileges and immunities established in the treaty have not been enforced, and thus that Estonia's actions do not breach the Broadcasting Treaty.
Can I probe that a little bit? Article 36 deals with the situation where the station is no longer performing the functions envisaged. But isn't there a difference between that and saying that the station is performing, in addition, other functions which were not envisaged?
Your Excellency, in Estonia's contention, it is not. When the treaty uses the term envisaged, it makes reference to the intention of the parties at the time of conclusion of the treaty, and this intention, under Estonia's contention, is expressed in the preamble, and therefore, by doing these particular types of activities, Rusland has stopped performing the functions that the treaty foresaw or envisaged.
Well, doesn't that create a bit of a problem for you if you put your case as broadly as that? Because surely the provisions on immunities here are very similar to the provisions on immunities in the Vienna Convention on Diplomatic Relations. That convention also refers to the sort of wonderful ideas of mutual intercourse between states and so on. But I don't think it will come as a surprise to anyone to be told that occasionally people in diplomatic missions engage in the same sort of acts that the Carmen program involves. Aren't you leading to a conclusion that an embassy is no longer an embassy and therefore the immunities of the diplomats are forfeit if the embassy is engaged in espionage as well as in diplomacy?
No, Your Excellency, this case must be clearly distinguished from the case of permanent diplomatic missions. In fact, the Vienna Convention of 1961 does recognize similar privileges and immunities, but those immunities apply to permanent diplomatic missions, and that treaty, as well as the Vienna Convention on Consular Relations of 1963, provide for a remedy in case of abuse of the privileges and immunities, namely the declaration of persona non grata and or the expulsion of the agent from the state. In fact, this court, in the Tehran hostages case, stated that diplomatic law is a self-contained regime as it contains the remedies for a breach of its own norms or an abuse of the privileges and immunities. But in this case, the Broadcasting Treaty contains no such remedy.
I cannot resist the question of asking you what you mean by a self-contained regime.
Honorable Judge Simma, by self-contained regime, I am referring to a field of law where the remedies for a breach of the substantive norms are contained within the same legal field or regulation. And in this case, the Broadcasting Treaty thus established a remedy in case of non-performance, which is the cessation of the privileges and immunities. Moreover, with regard to the seizure and forfeiture of the VOR station, Estonia submits that these actions constituted a legitimate exercise of its police powers under customary law, as recognized by the Iran-US Claims Tribunal in SEDCO and arbitral panels in cases such as Saluca, Methanex, SD Myers, El Paso. States are allowed to interfere with the use of property as part of their police powers if these actions are done with a public purpose and in accordance with due process. In this case, the seizure and forfeiture of the VOR station were conducted during a criminal investigation.
Counsel, it's hard enough for this case to accept the decisions of other international courts as highly relevant. Now you refer to decisions of investment, awards and investment arbitrations. Where would you rank them with regard to authority compared to the European Court of Justice or?
Of course, these cases that I have mentioned do not constitute judicial decisions as such, but they do recognize the existence of customary rules of international law, which this court is bound to apply under Article 38(1)(b) of its statute.
Do you stick to what you said, that the awards of investment arbitration tribunals do not constitute judicial decisions in the sense of the ICJ judgment?
Yes.
Where else would you put them? In what category?
There are not strict categories in terms of hierarchy of sources before the court, Your Excellency, but this court could rely on the interpretations of customary law that these cases and the arbitrators in all these tribunals are clearly highly qualified publicists. Moreover, this court could then take them into consideration as subsidiary means, but Estonia's contention is that they recognize rules of customary law, and these rules are applicable to the case at bar. Lastly, with regard to Margaret Mayer's arrest, there are no grounds under international law to state that they were entitled to any sort of personal immunities. They are not diplomats within the meaning of the Vienna Conventions of 1961 or 1963, and they do not enjoy special mission immunities. First, because Estonia and Riesland are not parties to the Convention on Special Missions of 1969, and secondly, because there are no customary rules regarding special missions. In fact, in the case of Djibouti, before this very court, Djibouti argued that the special mission conventions reflected customary law, but this court, having the opportunity to decide whether this codified or not customary law, did not do it. And therefore, Estonia submits that Mayer and the other employees were not entitled to any other sort of immunities. As my time has expired, and if I can be of no further assistance, I will yield to my co-agent.
Thank you.
Thank you.
Now you may start.
Thank you, Mr. President. Mr. President, Your Excellencies, may it please the Court. My name is Belén Ibáñez, and I will continue with the applicant's pleadings before this honorable bench. As my co-agent has indicated, I will be dealing with submission number 3, concerning Joseph Kafker's unlawful detention under the Terrorism Act, and submission number 4, concerning the cyber attacks perpetrated against the Enspost and Jester and Walsingham. With the Court's permission, I shall now address the issue of Joseph Kafker's detention. First, Estonia is entitled to exercise diplomatic protection on behalf of Kafker since he's an Estonian national and all the available local remedies in Friesland were duly exhausted. Second, Joseph Kafker's detention under the Terrorism Act is incompatible with Friesland's obligations under the ICCPR. According to the Terrorism Act, detentions can only take place if the National Security Tribunal issues a warrant. However, there is no evidence in the compromise indicating this occurred. Since Friesland has not respected its own domestic law by arresting Kafker, it has violated Article 9.1 of the ICCPR, which establishes that detentions must take place in accordance with the domestic procedures established in the law of the detaining state. In fact, Your Excellencies, the European Court of Human Rights in the case Savaro v. Bulgaria, that was ruled 2 days from today, held that the detention order must be issued immediately and that its absence could in itself affect the lawfulness of his detention. In fact, in paragraph 74 of that case, the court held that the failure to observe domestic law gives rise to a breach of Article 5.1 of the European Convention on Human Rights, which is identical to Article 9.1 of the ICCPR. And the court held that, and I quote, "The absence of a written warrant cannot be described as a minor procedural omission," end of quote. Further, Your Excellencies, Joseph Kafker's detention is arbitrary. The Human Rights Committee, in its General Comment 35, has explained that arbitrariness is not to be equated with against the law, but that it also includes elements of injustice, inappropriateness, lack of foreseeability, and due process of law. Here, Your Excellencies, Joseph Kafker has been detained without hope of release for more than a year. He remains without charges in a maximum security facility, and his due process rights recognized under Article 9.4 have been continually violated by the proceedings before the National Security Tribunal. This court should just decide that his detention is arbitrary.
Counsel, may I just ask you, are you saying that the arrest itself, the fact of his being detained at all is arbitrary, or simply that the length of time and the conditions under which he has been detained amount to arbitrary behavior?
Your Excellency, Estonia's submission is that first, his detention is unlawful because Friesland has not issued the warrant guaranteed in its domestic law.
Yes, sorry, I've understood that submission. I'm not asking you about legality, I'm asking you about arbitrariness. Are you saying that the entire detention, the very fact of taking him into custody was arbitrary, or simply that the arbitrariness arises from the conditions in which he's been detained and the length of his detention?
The conditions, Your Excellency. Estonia is not submitting before this court that the regime of preventive detentions per se is unlawful or arbitrary or that it violates the ICCPR. However, the Human Rights Committee, in the case Cámpora v. Uruguay, established that preventive detentions must comply with the requirements established in Article 9 of the ICCPR, save for Article 9.3, which is also only applied to individuals that had been charged for a crime. And here, Your Excellencies, Joseph Kafker has not been charged for any crime.
Counsel, a question. Has the exchange you have had with Judge Greenwood reminded me of something that took place at the International Court of Justice about 10 years, less than 10 years ago, and maybe, does it ring a bell with you?
The Diallo case, Your Excellency?
That's the right ring of the bell, correct? But even more personally, because I think there was I don't know what type of opinion, but it is, I think Judge Greenwood had a little problem with a part of the decision of the court.
In the Diallo case, the court found a violation of Article 9.1 because the Congo had not complied with its domestic law by informing Mr. Diallo of his expulsionary decree. Your Excellencies, Friesland has also violated Article 26 of the ICCPR, which guarantees the equality before the law of all individuals, including aliens. This is due to the fact that the Terrorism Act allows the Icelandic government to indefinitely detain foreign nationals, whereas Icelandic nationals that may pose the same threat are left free. The Human Rights Committee, in its General Comment 18, has established and has explained that the ICCPR forbids states to enact legislation with a discriminatory content, and this is exactly what Rusland has done in 2003 by enacting the Terrorism Act. Further, Your Excellencies, Joseph Kafka was not informed of the reasons for his arrest, as expressly established in Article 9.2 of the ICCPR. The Human Rights Committee, in the case Drescher Caldas v. Uruguay, held that detainees are entitled to hear the substance of the complaint against them, and that mere references to the detention's legal basis does not satisfy this requirement. Here, Your Excellencies, and according to paragraph 32 of the compromise, Joseph Kafka was detained, and I quote, allegedly in accordance with the Terrorism Act, end of quote. He was not given any further information, and he remains to date without said information. In fact, the former Special Rapporteur on Human Rights while countering terrorism, Martin Skinning, has explained that national security is not an excuse for non-compliance with this rule. Further, the proceedings before the National Security Tribunal have precluded Kafka from effectively challenging the lawfulness of his detention, as it's guaranteed in Article 9.4 of the ICCPR. This is due to the fact that Joseph Kafka did not receive the evidence held against him. He could neither consult nor issue instruction to his special advocate, and he could neither challenge nor question the witnesses against him, because first, he was not present during the National Security Tribunal proceedings, and second, because the Bureau officials gave their testimonies with both their faces and voices blurred.
Why does that prevent him from challenging their evidence?
Because first, all that evidence was deemed closed material by the National Security Tribunal, and by virtue of the Terrorism Act, Joseph Kafka's special advocate could not consult regarding that materials with the detainee.
Well, I know that's a problem in lots of cases where there is highly sensitive evidential material, and Friesland would not be the only country to have used a special advocate procedure. But my question was actually about a different point. Why does the fact that these agents gave evidence by video link with their names not disclosed and their faces blurred, why does that make any difference?
Your Excellency, the European Court of Human Rights in the case Al-Kawaja and Tahiri versus UK held that as a general rule, detainees might be entitled to challenge and question witnesses against them. And when this is not possible, sufficiently counterbalancing factors must be set in place. For example, the redaction of the testimony of these witnesses. In fact, in the American Court of Human Rights in the case Norin Catrimán versus Chile, which involved the employment of anonymous witnesses pursuant to a terrorism act, held that one of these counterbalancing factors is that the detainee must be able to at least challenge the testimonies given by these witnesses in order to raise doubts about the reliability of their testimonies. Here, Joseph Kafka was precluded from doing so because first, he could not hear what these testimonies said, and second, because of the conditions of their witness.
Yes, I don't quite see that. I can see that, just focusing on the point about the anonymity of the witness, if this is an allegation of, for example, a sexual offence, then it might be very important to know who is making the allegation, might be critical. But where it is intelligence agents referring to material that they have acquired, the identity of the intelligence agent is unlikely to be a material factor. It's unlikely to be something that would strengthen the special advocate's cross-examination.
Indeed, Your Excellency, and Estonia will readily admit that Friesland is in all its right to protect the security of its intelligence agencies, but it is not reasonable to cover their identities and to protect them and to preclude Kafka from watching and seeing what they, what they have to say in order to prepare his defense. Proceedings cannot be deemed adversarial or to ensure equality of arms unless the detainee is given sufficient information in order to prepare his defense. This lack of disclosure of the information is not sufficiently counterbalanced by the implementation of the special advocate system, such as the one that Friesland has implemented in the Terrorism Act. In fact, the European Court of Human Rights in the case A and Others versus UK, paragraph 220, held that the special advocate cannot perform his duties in any useful way unless the detainee is given sufficient information in order to issue instructions to his lawyer. And here, Your Excellencies, Joseph Kafka did not receive that evidence, and he could not either issue instructions to his lawyer. For all these reasons, Your Excellencies, it is Estonia's contention that the proceedings before the National Security Tribunal have violated Joseph Kaspar's rights under Article 9.4 of the ICCPR.
Mr. President,
Yes.
would you mind if I ask Council to move to the next submission?
Yes, please.
Because it gets me to one of my favorite subjects, namely state responsibility and attribution. So with regard to the attribution or attributability of the hacking of the Chester and Walsingham computers, where would you kind of locate them in the ICJ system of attributability?
Your Excellency,
Sorry, not ICJ, I'm sorry, the International Law Commission work on state responsibility.
Your Excellencies, it is Estonia's contention that these cyber attacks are attributable to Rusland under Article 4 of the International Law Commission's Articles of State Responsibility, because...
Why is it that you don't say draft articles? You said articles?
Excuse me, I will...
No, it's right. They are articles. I just want... No, because there is a little difference because of the treatment, what happened to the articles when they moved from Geneva to New York and were treated by the General Assembly. Do you know what the General Assembly did with the draft article submitted by the International Law Commission in late 2001? Did they welcome them, adopt them? Did they kind of transport them further with a view to turning them into a draft convention, or what do you know?
Just to follow it up, what is your understanding about the different procedures applied to the articles on state responsibility by the IRC and the draft articles submitted by the IRC on the law treaties, for example?
Mm-hmm.
I'm sorry, I cannot assist the court on that matter. I know that they were presented before the United Nations General Assembly in 2001, but they were approved further. They were not rapidly adopted by the United Nations General Assembly. Okay. It is Estonia's contention that these cyber attacks are attributable to Rusland because all the evidence in this place points to the fact that the Bureau conducted the cyber attacks. Under Articles 4 and Article 7 of the International Law Commission's Articles on State Responsibility, states bear responsibility for the acts or omissions of state organs, even if they are acting ultra-vires. And the Bureau is a Ruslandic organ under its domestic law, and therefore it can engage its international responsibility. Moving on to the evidence in this...
I think you can take it for granted that the acts of the Bureau are attributable to Rusland, but what is the evidence on which you rely to say that this was the act of the Bureau? That's the more interesting question.
Yes. Experts from the Estonian Institute of Technology traced the malware used to IP addresses within Rusland's territory. Further, they reported that the computers employed in the cyber attacks were associated with governmental cyber infrastructure located under the exclusive control of Rusland.
I'm afraid I'm a bit of an amateur where technology is concerned. Perhaps Judge Simma will be better advised about this, but is it not possible to create the impression that an IP address is located in one country when in actual fact the work is being done somewhere else? I seem to have heard something about that.
Yes, it is called IP spoofing, Your Excellency, and indeed that can happen. Your Excellencies,
what is the evidence that this is not an IP spoofing case?
The facts of the compromise cannot shed light on this subject. However, it is Estonia's contention that all the evidence submitted before this court today is circumstantial evidence. Also known as indirect evidence, it allows to arrive to conclusions that indirectly establish the existence of a fact or an event. This very court resorted to circumstantial evidence in the Corfu Channel case to find Albania responsible. And in that case, this court explained that states may resort to circumstantial evidence, provided that first, all the direct proof is under the exclusive control of the other state party, and second, that there is neither direct proof nor accepted facts that contradict such circumstantial evidence. In this case, all the direct proof is under the exclusive control of Rusland, and according to paragraph 39 of the compromise, Rusland merely refused to answer to Estonia's allegations regarding its involvement in the cyber attacks. And second, there is no evidence in the compromise that contradicts all the circumstantial evidence presented before this court by Estonia.
But is it not true that from the viewpoint of Estonia as applicant, you have the burden of proof to establish that this attribution goes to Friesland, not somebody else who is trying to make use of this scientific technological device. In other words, my point is that in your view, the factors that you have mentioned is sufficiently credible and sufficiently high to conclusively establish that there is a case of attribution which you can attribute to Friesland.
Yes.
What is your authority for saying that?
Your Excellency, in the Corfu Channel case, this court held that researchers' circumstantial evidence must not leave room for reasonable doubt, and it is Estonia's contention that this is sufficient to discharge Estonia's burden of proving that Friesland actions are attributable to it. In any event, and according to Article 49 of this court statute, the court could order Friesland to issue and to provide more information, or under Article 50 of that court statute, it can appoint independent experts. For all these reasons, Your Excellencies, and allow me to note that according to paragraph 35 of the compromise, only 8 days before the cyber attacks took place, Attorney General De La Ponte from the Icelandic government stated that Friesland would do anything in its power to disrupt the publication of these documents. And therefore, it is Estonia's contention that Friesland was specifically interested in the disruption of the cyber and bootmaster records of these two corporations. I will now proceed with the violations committed by Friesland, Your Excellencies. First, Estonia, as a sovereign state, enjoys sovereignty over its territory. As it was interpreted by the Tallinn Manual on the International Law applicable to cyber warfare, states exercise exclusive control and authority over all cyber infrastructure, whether private or governmental, located within this territory. Therefore, a cyber attack such as the one in the case at Bar has precluded Estonia from exercising exclusive control and authority over the cyber infrastructure located within this territory, and therefore it has violated the territorial sovereignty of Estonia. Allow me to note, Your Excellencies, that the Tallinn Manual is an academic study done by international scholars who are experts in the field of cyber operations, and therefore this court could consider them as the teachings of the most highly qualified scholars in the terms of Article 38(1)(g) of this court statute.
Counsel, is it a coincidence that that manual was elaborated in Tallinn?
No, it wasn't, Your Excellency. Tallinn is from Estonia, who suffered in 2007 serious cyber attacks, indeed. And in that case, experts analyzed the cyber attacks of Estonia and held that if they had been attributed to a state, they would have constituted a breach of the territorial sovereignty of Estonia and the principle of non-intervention. By virtue of this principle, states must refrain from interfering in the domestic affairs of other states by using elements of coercion. It is Estonia's contention that after it refused to return the leaked documents, the cyber attacks intended to compel Estonia to change its sovereign decision regarding these documents. And in fact, responding in its written memorial, specifically in page 32, has acknowledged that this was the aim of the cyber attacks. Your Excellencies, this is the ultimate way of coercion. Not only did respondent wanted Estonia to behave in a certain way, but Friesland went and did it for itself. That constitutes a breach of the principle of non-intervention. Even if this court considers that the cyber attacks are not attributable to Friesland, the failure to prevent them also engages its international responsibility. This court has held in cases such as Corfu Channel or Palm Mills case that states must not only allow the use of its territory for acts contrary to the rights of other states. As it was interpreted by the Tallinn Manual, this entails the state duty to prevent the launch of cyber attacks that are detrimental to the rights of other states from the state's territory.
Excuse me, you said, you quoted the passage from the judgment of the court, of the International Court of Justice,
yes,
and saying that the state should not allow knowingly to use that territory. Now, how do you establish that Friesland, in this particular case, knowingly allowed that that technique to be employed from the territory of Friesland?
Because, Your Excellency, for example, in the Corfu Channel case, the court held that Albania knew about the unlawful use of its territory because after the mines exploded and caused detrimental effects to the UK, it conducted no thorough investigation in order to get to know what had happened. And in this case, Friesland has done the same. After the cyber attacks took place, it has done nothing in order to find who were the authors of the cyber attacks and to punish them. For all these reasons, Your Excellencies, Friesland's passiveness and indifference towards the launch of cyber attacks from within its territory violate this due diligence principle. In fact, Professor Michael Schmidt, who was the I see my time has expired, Your Excellency. So,
Professor Martin Smith, who is he? Sorry, Professor.
Can I answer His Excellency's questions, Mr. President, briefly?
Yes. Is it not true that in the Corfu Channel case, the courts made the argument that why the court used the expression knowingly, because there was a watching tower on the land territory of Albania to be able to see what was happening in the Corfu Channel. In this particular case, is it not true that Estonia, as applicant, has to establish that they must have good reason to have known that? But I'm just wondering what is the basis for that argument?
Allow me to note, Mr. President, that according to paragraph 1 of the Compromis, Friesland has a world-renowned technology and communication sectors, and further, it has conducted mass surveillance over all Amazonian nationals, and therefore, it has a world-renowned. Given these two facts, it is Estonia's contention that Friesland knew or ought to have known about this use of its territory. If I can answer His Excellency's question?
30 seconds.
Yes. Professor Michael Smith is the editor of the Tallinn Manual and has analyzed the Sony attacks of 2014 and held that the due diligence principle was also applicable even if the cyber attacks were aimed at a private corporation such as Sony. In this case, Chester and Walsingham and the Enspost are both private corporations, and therefore the due diligence principle also applies in this case.
Thank you.
If I can be of no further assistance to this court, I will now yield to respondent. Thank you.
Thank you. Thank you, agent of the applicant state. Now I invite the agent of the respondent state, the Federal Republic of Friesland, to speak. Now you may proceed.
President Owada, Honorable Judges Simma and Greenwood, agents for the applicant, good afternoon, and may it please the court. My name is Alexander Bedrosian, and on behalf of my co-agent, Ms. Adria Moshe, and our of-counsel, Ms. Camilla Ihenetu, we are privileged to represent the Federal Republic of Friesland, the respondent in this dispute. I will be speaking first for 22 minutes regarding Friesland's intelligence gathering programs and Estonia's actions against the Voice of Friesland station and employees. Ms. Moshe will speak second, also for 22 minutes, regarding the detention of Mr. Kafker and the cyber operation. At this point, we would like to respectfully request 1 minute for Sir rebuttal. Thank you. In the face of emerging threats, Friesland has balanced its sovereign responsibility to protect its citizens' security and its obligations to respect human rights.
Excuse me, what do you understand by sovereign responsibility? The sovereign responsibility?
And that it is
What's that supposed to mean?
First, international law that does place obligations onto a state to protect its citizens. Specifically, in this case, Friesland is a state party to the International Covenant on the Suppression of Terrorism Bombings, and we would submit that it is an inherent part of sovereignty that a state is responsible for the protection of its citizens.
Is it possible for the agent to change your order of presentation in such a way that it will correspond to the order of issues which have been listed in the application and the response presented by the respondent? In other words, starting with the question of admissibility.
Certainly, Your Excellency. On the question of admissibility, the illegally obtained information about Friesland's intelligence gathering programs, with the exception of the information about the detention of Mr. Kafker should not be admitted before this court. Article 48 of this court's statute gives this court discretion to make all arrangements regarding the taking of evidence. Riesland urges this court to use its discretion to uphold the rule of law by refusing to admit evidence that was illegally obtained from a party and to whose inclusion that party explicitly objects.
Counsel, if you're invoking the rule of law as a reason for excluding this evidence, you are surely on rather thin ice, given that the material on which you are relying also involves breaches of the rule of law, because you've been relying on material obtained in another country through covert means.
Which evidence are you referring to, Your Excellency?
Well, the evidence about the threat to the station. Why it was that Miss Meyer was able to know in advance that the station was going to be raided. Are you not relying on that?
We are not relying on that, Your Excellency.
Could I ask you a related question?
Yeah.
What precisely do you mean by rule of law?
That this court should not encourage the violation of states' domestic laws by admitting evidence that was illegally obtained from a state. This court and other international tribunals have done this in the past, excluding evidence that was illegally obtained from a state, even by non-state actors, and even when the information had subsequently been published on media as the evidence today.
When has an international court excluded evidence on that ground?
This court, in the diplomatic and consular staff in Tehran case, in a provisional order of December 15th, 1979, did not let Iran use in its counter...
Excuse me, what is a provisional order?
It is an order... It is an order that the court gives in advance of a judgment in order to preserve the integrity of the proceedings, Your Excellency.
Was it an order on a provisional measure?
It was cited as a provisional order of December 15th, 1979, Your Excellency. And in that provisional order, this court did not let Iran use in its counter-memorial evidence that militants whose conduct had not yet been attributed to Iran had stolen from its American embassies, despite the fact that a lot of that information had already been widely disseminated on Iranian media.
But Iran didn't appear in that case. It didn't put in any evidence.
Yes, Your Excellency, but the provisional order was in response to a letter Iran had sent to the court in which it stated that the material stolen from the American embassy contained evidence of over 25 years of interference by the United States through its embassy in Iranian affairs. This court invited Iran to submit its claims formally as a defense in a counter-memorial, but first to return all of the evidence that had been stolen from the embassy, thereby suggesting that Iran could not use the stolen information in its counter-memorial. Similarly, the Investment Arbitral Tribunal in EDF versus Romania, which Riesland would contend is persuasive authority under Article 38(1)d of this court statute, and particularly persuasive because the procedural provision in governing that arbitration, ICSID Arbitration Rule 34(1), is almost identically worded to Article 48 of this court statute. In that case, the tribunal excluded evidence that a journalist had obtained in violation of Romanian law and had published in an article published on the Financial Times website, analogous to the situation with Mr. Frost here. But even if this court were to admit the evidence, it does not show any violation of international law by Riesland through its intelligence gathering programs. To take the arguments in the order in which applicant presented them, this is for several reasons. Beginning with the Verismo program, which was the collection of data from with the pod on the undersea cable. First, applicant lacks standing in this case. Second, the ICCPR obligations do not apply to the Verismo program. And third, the substance of the ICCPR's Article 17 right to privacy was fully complied with in this case. First, applicant lacks standing to bring claims on behalf of its nationals who were surveilled. Applicant relied on the Articles on Diplomatic Protection, Article 15C. However, the commentary to that article in paragraph 7 provides that the exception to the rule of local remedies applies only if the applicant can show that it is unreasonable or would cause great hardship to the injured alien to exhaust local remedies.
I have a problem. I have a problem seeing how the draft article on diplomatic protection fits the situation, where a state claims that it is in the interest of its whole population to be left alone, not to be heard, to rely on something which is so obviously tailored for a different scenario.
Yes, Your Excellency. Applicant is seeking to enforce individual rights. The Human Rights Committee, relied upon by applicant in its General Comment 31, made clear that the rights under the International Covenant for Civil and Political Rights are accorded to individuals. That while states have a legal interest in the enforcement of these rights, the individuals are the rights holders. But this framing of legal interest does not give the state standing, as this court noted in the Barcelona.
So you take the view that in case of a human rights treaty, like the Covenant on Civil and Political Rights, it is the individuals that have individual rights, that the states parties do not have rights to see that other states do not violate. Could you give your answer in the light of the recent decision of this court in the Belgium v. Senegal case?
That case involved the violation of a right that was erga omnes, the prohibition against torture. However, the right to privacy has not been recognized as an erga omnes right.
To quote a different case then, if you say that the right of the individuals does not necessarily give rise to the right of the state, what is the authority for your saying that these are mutually exclusive? In the Owada case, Mexico did argue that this was a case of both the diplomatic protection and the violation of the treaty right of the state. So these can coexist side by side with each other.
Yes, and in the Owada case, the court acknowledged that it was a mixed claim, and it looked to see which claim was more preponderant, and it found that the violation to the state rights for its consuls to have access to its detained national prevailed. But even if applicant does have standing, it is not established that the International Covenant was engaged by the Verismo program. Article 2 of the Covenant provides that a state's obligations apply not to anyone affected by a state's conduct, but only to individuals subject to the jurisdiction of the state. And this court and the Human Rights Committee has applied the Covenant extraterritorially only in cases of military occupation or physical detention, neither of which are applicable here. State practice supports this view that...
Can you indicate a case where this court has recognized the extraterritorial application of economic, social, and cultural rights? And if yes, in what context?
Yes, in the Palestine Wall advisory opinion, it acknowledged that even though the rights under that covenant, it noted, were essentially territorial, they would be applied extraterritorially to territory over which a state asserted effective control. But again, that was a case of military occupation, which is not applicable here. Even if the ICCPR does apply to the program, however, its substance was complied with. The Article 17 right to privacy permits interferences with privacy as long as they are lawful and that they are not arbitrary. The Verismo program was lawful. While applicant focused on only the Security Services Bureau Act, the proper inquiry is into the entire comprehensive legislative scheme governing the surveillance. And here, the Act, as well as the Attorney General regulations, as well as public statements by Riesland's Prime Minister, which can take on legal effect under this court's jurisprudence in the nuclear test cases, collectively provide a legislative framework for the surveillance program. The surveillance program was also not arbitrary. The Special Rapporteur, Ben Emerson, in his 2014 report on countering terrorism, on the fundamental freedoms while countering terrorism, provided that mass surveillance programs are not automatically prohibited, but that they can be proportional if two requirements are met. First, if there is a macro justification for the program, in other words, a showing of why it was necessary to collect a wide range of surveillance, and second, if there are sufficient safeguards to counterbalance the initial bulk collection. Both of those requirements are met here. Turning to the macro justification, Amestonian activists were promoting and planning terrorism by using websites that allowed them to conceal their identity. Riesland's security officers therefore needed access to a wider range of communications in order to pierce the anonymity, as they were able to do, as shown in paragraphs 17 through 19 and 22 of the Compromis. However, in order to ensure that such...
So what you say is that your, let's say, surveillance program was installed as a reaction to prior activities hostile to your country? So is that the right chronology?
Yes, the terrorist threat from the... Well, there are two answers, Your Excellency. The first is that terrorism is an ongoing threat. However, the particular threat in this case did arise a few weeks after the program began.
Was there any preceding or terrorism before the activities that we deal with in the case set in that would have justified Riesland to engage in the kind of spying that you're trying to justify?
The Compromis is silent on that. However, terrorism, Riesland would submit, is an ongoing threat. And second, at the time the program was begun, there was virulent debate about the policy changes that the eventual terrorists hoped to effect. And third, this only goes to the overbroad relief that applicant is seeking. Applicant is not seeking a declaration that for the intervening 4 weeks, the program was unlawful. It is seeking the dismantlement of the entire program, despite the fact that the terrorism threat today exists. But the program also has 3 critical safeguards to render it proportional, and the most persuasive authority here is the European Court of Human Rights case in Weber versus Germany. Riesland would submit that this is the most persuasive case because it is the only case where an international or a regional court has upheld a mass surveillance program and could therefore set the minimum requirements for lawfulness. The safeguards are use restrictions, storage restrictions, and oversight. And on all 3 issues, the Verismo program is more stringent than the German program. Turning to applicants' contention that the Carmen program violated territorial integrity as well as the United Nations Charter. In terms of territorial integrity, applicants misattributed what was in respondents' written submissions. In no place in respondents' written submissions did the respondents submit that intelligence gathering on a state's territory without that state's consent is unlawful. Per the Lotus principle, in order to show that this was a violation of territorial integrity, applicant may not just show that international law does not affirmatively authorize such conduct, but that it prohibits this conduct. In order to show such a prohibition in customary international law, applicant must show that state agents who are invited into the territory of another state refrain from gathering intelligence. Applicant cannot do this because state agents who are invited into another state gather intelligence all the time, as was noted by Judge Greenwood in the form of diplomats. Turning to applicant's claim regarding...
Counsel, I'm grateful to you for picking up what I asked counsel for the claimant state, but let me just put the point to you. Doesn't the Broadcasting Treaty invite these people in for a specific purpose? And does it not, which is not espionage, and does it not also call upon them to respect the laws in force in Amastonia?
It does, Your Excellency. However, again...
So were they respecting the laws in force in Amastonia?
They were not, Your Excellency. However, this violation of domestic law does not rise to the level of an international law violation.
So if a state invites officials of a foreign country onto its territory for a specific purpose and only for that purpose and subject to an undertaking that those officials will respect the law in force in that country, it's not a breach of international law if those officials then completely disregard the law in force in that country and engaging in a quite different purpose. Is that the essence of your submission?
I hope you are not suggesting that what is provided for in the Broadcast Treaty, which is an international agreement, is an obligation under national law, but not international law.
No, Your Excellency. Respondent merely submits that state practice does not show that when state agents are invited onto the territory of a foreign country for one purpose, but then engage in intelligence gathering, that is a violation of territorial integrity because there's widespread state practice of this happening.
But it would be a violation of the treaty, would it not?
No, Your Excellency.
So the practice that, let's say, in the ambit of Christianity, the Ten Commandments are violated all the time across the board, cancels their obligations out, because that's the point you wanted to make, is that it's done by everybody, and therefore an obligation to not engage in certain activities on another state's territory into which you have been invited does not rise to a breach of international law because it's done by all the others. That's how I understood you. Maybe you clarify. I think it also relates to what the President has asked you.
Certainly, Your Excellency. The difference with the Ten Commandments example is that the Ten Commandments...
But they don't fall under 38, so don't maybe general principles, right?
Sure,
Yeah,
sure.
Okay.
So when a rule already exists, for example, in a treaty or in the Ten Commandments, conduct inconsistent with that rule does not show that the rule no longer exists. This court made that clear in Nicaragua. But first, the rule, the prohibition, must be established. An applicant cannot establish that prohibition in the face of such inconsistent state practice.
But the prohibition here is explicit in the text of the Broadcasting Treaty. It's a requirement for the officials to comply with the law of the host state. Thou shalt not commit adultery. It can be read in a number of different ways, I'm sure, but it can't be read as saying thou shalt not commit adultery, but in fact adultery is quite all right.
Yes. I will refrain from commenting on that latter judgment, however...
Probably just as well as you can.
Riesland's submission is in response to applicants' claims which were not under the Broadcasting Treaty, but under territorial integrity pursuant to customary international law. But on to the Broadcasting Treaty, it was Estonia that violated the Broadcasting Treaty, the immunities provided therein, when it arrested the VOR employees and seized the VOR station. Applicant relies on this court's precedent in the U.S. rights of U.S. nationals in Morocco case to the extent that this court considered the preamble, but applicant did not consider how this court considered the preamble. This court gave more weight to that preambular provision that most closely connected to the operative terms of that treaty, which was about economic and customs matters.
I don't want to pursue this point further because of the lack of time, unfortunately, but it sounds as if you are saying that the particular article in the Broadcasting Treaty which imposes certain obligation under international law, under the treaty itself, the contents of the obligation lying in the fact that it has to observe, it has to abide by the national laws of the country. Now, by taking that, you seem to have been suggesting that it's a question of the national law and not a question of international law. But the fact that the obligation was created by the Broadcasting Treaty means that it is an international obligation. The contents of it is the observance of the national law, but the obligation, the nature of the obligation is an international obligation. Now, if that is the case, are you suggesting that privilege and immunities has nothing to do with this limited function of the personnel allowed to get into the territory of Estonia?
Two responses, Your Excellency. First, regarding Article 23.1. Article 23.1 puts the obligation on the persons employed by the station. It does not put the obligation on the state. It does not say that the state must ensure that its employees follow the laws of the host country. Second, to the point of the immunities, The station's functions are set out in Article 2, which relate to broadcasting for local audiences. That never ceased in this case. And turning back to this court's consideration, I see that my time has expired. May I briefly finish my answer to Mr. President's question?
Thank you. You can finish your answer briefly, given the time factor.
Yes. The purpose of the treaty is set out in Preambular Clause C, which is to promote cultural exchange between the parties. Because the station consistently broadcasted up until it was raided, the immunities never ceased. For that, we asked this court to adjudge that Riesland did balance its human rights obligations with its counterterrorism objectives, and Estonia violated the broadcasting treaty. I cede the floor to my co-agent. Thank you, Your Excellency.
Thank you, Agent. I now call upon the second agent of the respondent state, the Federal Republic of Riesland.
Mr. President, Your Excellencies, agents for the applicant, good afternoon. My name is Adria Moshe, and along with my co-agent, Mr. Bedrosian, and our of-counsel, Ms. Ahenatu, I have the privilege of representing the Federal Republic of Riesland, the respondent in this case, in its third and fourth submissions regarding the detention of Joseph Kafker and the cyber operations targeting the Ames Post and Chester and Walsingham. Now today, applicant has argued that it is entitled to the release of a suspected terrorist to their custody without establishing any ICCPR violations, much less violations that would justify release. It has also argued that it is entitled to compensation on behalf of its private citizens without establishing that the cyber operations are attributable to Riesland or that they constitute an internationally wrongful act. Turning first to the issue of Joseph Kafker. Again, applicant has argued that Mr. Kafker's detention is not lawful under ICCPR Article 9.1 and that it does not follow proper procedures, violating Article 9 generally. However, Riesland's primary submission is that it has complied fully with its human rights obligations applicable to preventative detention under the ICCPR because first, Mr. Kafker has been lawfully detained pursuant to the Terrorism Act to contain the present and direct threat that he and his cohorts in the hive present to Rieslandic public safety, as well as the fact that he has been afforded prompt and ongoing independent judicial review. Turning to applicant's first argument regarding the warrant requirement stated in compromis clarifications paragraph 2. First of all, we would like to turn this court's attention to the fact that the compromis is actually silent as to whether or not a warrant was issued, and that this court should not read silence as affirmatively establishing noncompliance. We would also turn this court's attention to its Diallo opinion, where it stated that it is for domestic courts in the first instance to determine compliance with domestic laws, and that only when an interpretation put forth is manifestly absurd would the court replace a domestic court's judgment with its own. Here, Riesland submits that it did comply with the warrant's requirement, despite the fact that we do not have evidence of its compliance, because in any event, the purpose of a warrant, which is to prevent arbitrary detention through judicial control, was accomplished because Mr. Kafker was brought before the National Security Tribunal within 3 days of his initial detention. And that brings us to the next requirement under Article 9.1, under the prohibition of unlawful and arbitrary detention. Now, the arbitrary prong, which applicant did not address here, which is whether Mr. Kafker's detention is reasonable and necessary under the circumstances, that test was established by the Human Rights Committee in Van Alphen versus the Netherlands. And indeed, what the Human Rights Committee stated in its general comments, General Comment 35, as well as Shafiq versus Australia, that detention, preventative detention, which is the regime under Mr. Kafker is being held, would be appropriate and reasonable where it would prevent a direct threat to public safety and where it remains subject to periodic judicial review.
counsel. What has struck me also in the pleadings by your opponent, but also in your pleadings, is the very frequent reference to, let's say, soft law utterances, like general comments, decisions, etc., and very little hard law. Is that the problem? Where would you place the, let's say, a Human Rights Committee decision on an application on the basis of the optional protocol? Where would you place the authority? Where would you derive it from? And where would you place the authority or of a general comment of one of the treaty bodies?
Your Excellency.
I'm a bit worried about the foundation of all that stuff in the traditional hard law.
Your Excellency's concern is understandable, and in Article 38(1)(d) of this court statute, it does state that it can rely on the decisions of judicial bodies, judicial decisions, as persuasive authority to the extent that this court finds their interpretations persuasive. And as this court stated in the Diallo opinion, and as my learned colleague already stated, this court has said that the Human Rights Committee, the body which is tasked with the interpretation of the ICCPR, is to be afforded great weight.
So would you subsume the Human Rights Committee findings under the topic or the category of judicial decisions?
Yes, Your Excellency, the decisions that are under the optional protocol, to which neither Riesland or Amastonia is a party here, those decisions are judicial decisions. They are where individuals bring their complaints against a state, and where the Human Rights Committee then makes recommendations as to what should happen.
What makes a decision by an international body a judicial decision? Because I remember in my practice or in my experience in the United Nations human rights things, there were, let's say, expressions like quasi-judicial or almost judicial, etc. So what makes such an utterance a judicial decision? Don't there have to be certain guarantees or, let's say, procedural guarantees in the making of this? Yes, go ahead.
Yes, Your Excellency, and we would submit that what makes a judicial decision is the fact that it is a competent judicial body comprised, for instance, of qualified jurists, and a competent body which has the power to order an effective remedy in the case.
Is that the case in case of the Human Rights Committee, that the body has the competence to order with binding force?
No, Your Excellency, the Human Rights Committee doesn't have binding force. However, the parties to the optional protocol do agree to take those decisions and implement them in good faith.
Yeah. Okay, so what precisely are they bound to do with a decision, with a finding of the Human Rights Committee on an individual application? You say they agree on what? They agree to take it seriously, or?
The parties to a Human Rights Committee's decision would agree to take that decision and abide by it in good faith, which is precisely what we have here under the special agreement, where the parties agree to abide by this court's judgment in good faith after it renders its final judgment.
Agent, I think you have another important problem to address, so why don't you proceed?
Thank you, Your Excellency. Now, turning back to the Human Rights Committee's jurisprudence, Your Excellency, in General Comment 35 and Shafiq versus Australia, the Human Rights Committee has stated that preventative detention would be reasonable where it would prevent a direct threat to public safety. Now here, Mr. Kafker does present such a direct threat because he is suspected of contaminating a honey shipment to be distributed in Riesland with a toxic variant of neonicotinoids, which could have caused serious bodily injury to countless Rieslandic citizens had they ingested such honey. And indeed, the European Court of Human Rights, which we would not debate whether or not it is a judicial body in this instance, in Valderrama versus France, stated that allegations of terrorist activities, including the threat to national security and the risk of absconding, remained sufficient and relevant during a years-long investigation to justify Mr. Valderrama and others' detention during that time. Now here, Mr.
I
Kafka...
think on that particular point, the burden of proof lies with the registrant who claims that he has done all these things. And the evidence has not been produced against the background that this is a state security. How do you establish that or registrant is claiming is established by evidence, credible evidence, which the court can accept?
First of all, Your Excellency, this court would state that would turn its attention to its Corfu Channel decision, where it stated that where this court did not insist that the United Kingdom submit into evidence documentation as to whether the passage through the channel was indeed an innocent passage, document XCU, for instance, because it respected Britain's contention that those documents contain naval secrets and national security secrets. And this court should follow that approach here, which is also consistent with international tribunals' longstanding tradition that it is sovereign states who are in the best position to evaluate the threats that it faces and how to address their national security.
Well, Counsel, there's a big difference between this case and Corfu Channel with respect. In Corfu Channel, the mining of those British warships would have been unlawful even if the passage had not been innocent. Whereas here, you're trying to defend the detention of somebody without trial for more than a year. In those circumstances, are you not required to provide us with some indication, at least, of the evidential basis on which you are relying?
Yes, Your Excellency, and that evidential basis is present in Compromis paragraph 36. Again, the suspicion of Mr. Kafker's involvement in the honey contamination plot. In addition, he has senior ties to the senior echelons of the Hive, a group which is responsible for the 2014 warehouse bombings that caused the death of 2 Icelandic citizens, as well as 3 Amazonian citizens, and upwards of 70 million euros in damage.
Well, Counsel, I'm fascinated you draw our attention to paragraph 36, because if you regard that as evidence in support of your assertion, the only evidence here is the evidence from the Frost disclosures, which your learned leader has just told us are inadmissible in this court.
Your Excellency...
Are they admissible when it works in favor of the respondent, but not otherwise?
Your Excellency, as my co-agent mentioned, we do not object to the admission of the documents in paragraph 36. And again, our primary objection to the admission is the fact that Riesland does not consent to the admission of illegally obtained evidence.
But doesn't that undercut your team's entire argument on the admissibility point? If you maintain that the documents are inadmissible because they've been stolen, but that they can be admitted when they suit you, that's not an attractive position for a court to follow. Even Albania wasn't arguing that in the Corfu Channel case.
No, Your Excellency, but even if this court does choose to admit them, then this court should look to its jurisprudence in the armed activities in the Congo case and afford them little weight because they have not been corroborated.
Well, that would mean that we would afford them little weight in support of your current assertion as well.
Yes, Your Excellency, that is true. However, we would turn this court's attention to the European Court of Human Rights in the Fox, Campbell, and Hartley versus UK decision. And I would like to quote from that court's opinion when it talked about terrorism, where it stated that states cannot be asked to establish the reasonableness of a suspicion grounding arrest by disclosing confidential sources, supporting information, or even facts which would be susceptible of indicating such sources or their identity. And this court Riesland asked this court to find that Riesland has, in the face of the threat that Mr. Kafker poses, not forgotten its human rights obligations to Mr. Kafker. Indeed, Mr. Kafker has been afforded judicial review under Article 9.4. And turning to the review of Mr. Kafker's detention.
Agent, of course, it's up to you to divide how you divide the time allocated to you. But I just want to give you the warning that the time is running out, and you still have number 4 issue, which is a cyber attack issue, if I'm not mistaken.
Yes, Your Excellency. So I would briefly conclude on Mr. Kafker by stating that even if all of the allegations that Estonia submits were accepted by this court, the proper remedy would not be release of Mr. Kafker, but in fact would be review with the proper procedural safeguards in place, which is precisely what this court ordered in the Avena decision. For instance, in that case where the violation of the Mexican national's right to consular assistance was established, this court stated that the appropriate remedy was to establish whether the denial of such procedural rights would have impacted whether the nationals would have still been convicted. Here, the same logic holds true, where Mr. Kafker's procedural safeguards, which are only enshrined in Article 9, not Article 14.3 that Estonia seeks to include in Article 9, including the right to counsel and other rights, that those rights, if this court finds any procedural deficiencies, that those rights should be included, and prompt review would be the proper remedy as opposed to the release of a suspected terrorist, Your Excellencies. But in the interest of time, I will move on to Riesland's fourth submission, the submission regarding the cyber operations against the Ames Post and Chester and Walsingham. Today, Estonia has argued that the cyber attacks are attributable to Riesland by relying on the evidentiary principles that this court put forth in Corfu Channel. But it has failed to establish that the operation, even if attributable, is internationally wrongful. Now, first, turning to attribution. Attribution in the international system is a very high bar indeed, and simply put, Estonia has not established who carried out the cyber operations, much less that it was the Bureau or a third-party actor under Riesland's effective control. Now, we would remind this court that that the operations were, while they were traced back to Rieslandic government infrastructure and used what were believed to be segments of Rieslandic malware, that this is insufficient to establish attribution for two reasons. As applicant stated, this evidence is circumstantial at best, and no international tribunal has ever attributed conduct as opposed to an omission to a state through the use of circumstantial evidence, and this court should not be the first to do so in cyberspace, where circumstantial evidence is even less reliable in determining the actor's true identities than it is in traditional contexts.
Well, isn't it also true to say, counsel, that direct evidence is even less likely to be available in relation to cyber activities?
Yes, Your Excellency, and for that reason, we would focus on the circumstantial evidence and that portion of applicant's argument. But even still, applicant argued that in circumstantial evidence, that the evidence is in the exclusive control of Riesland. However, all of the evidence that Estonia has put forward from the AIT has in fact they have been able to ascertain on the World Wide Web. And we would argue that they would be able to obtain direct evidence such as email memoranda or some other type of information on the internet if they want to establish direct evidence to establish that this conduct is attributable to Riesland.
What is your argument against the claim that basically Riesland has exclusive control over the evidence in this area? And secondly, there are factors such as the code similarities, the report from the AIT, and the statement by Riesland's Attorney General comprising evidence, different inferences, that, the code similarities and the presence of government computer networks, these factors weigh very heavily upon favoring a particular conclusion through indirect evidence that you have just described.
Yes, Your Excellency. If we look at all of the evidence together, it's still insufficient to establish attribution because there's a wide range of alternate explanations for the malware and for the government infrastructure.
Could you give me the example of how you interpret the statement by the Attorney General of Riesland on this particular point?
Well, Your Excellency, there is a presumption that states act in good faith, and that any statement made by the Attorney General would be that his intention would be that any action that Riesland would take would be consistent with international law. However, what we would state as far as the rest of the circumstantial evidence that Amastonia puts forward is that the Tallinn Manual, as well as the UN group of governmental experts, both state that the mere fact that a cyber operation originates from the government infrastructure proves little in the world of cyberspace because of the wide range of alternate explanations, such as the fact that an IP address can be spoofed or faked, or that the computer could be hijacked as a bot. And indeed, even the malware piece of evidence also has an alternate explanation, which is the fact that it could be reverse engineered. So when we look at the cases that applicant has cited, which are the Estonia case, as well as the hacking of Sony Pictures Entertainment allegedly by North Korea, we see that after the Sony Pictures Entertainment hack, that legal scholars and cyber experts around the globe, including Mark Rogers, Bruce Shire, and Joe Ukill, found that such allegations were unsupported by those facts, and that those facts do not establish conclusively that North Korea was behind the attack. And indeed, the UN group of governmental experts states that that accusations of states organizing and implementing wrongful acts brought against both states should be substantiated. And this brings us to the second prong, which is the fact that even if these operations were attributable, they do not constitute an internationally wrongful act. And that is where state practice is instructive. If we look at, for instance, 3 separate instances of cyber operations against government infrastructure, not even private infrastructure, but government infrastructure, we see the United States, when its Department of Defense database was allegedly hacked by China, Iran after Stuxnet, which destroyed roughly 1/5 of Iran's nuclear centrifuges by causing them to spin out of control, or Estonia after the alleged Russian hackers swamped websites of Estonian organizations, including the Estonian parliament, banks, ministries, newspapers, and broadcasters. None of those states attributed that conduct to other states, nor did they characterize those attacks as a violation of the use of force or of territorial sovereignty.
Excuse me, are you making a distinction or confusing the 2 different issues? One is a question of attribution in the complexity, technological complexity involved in this particular case. The question arises as to how high the level of attribution should be applied. The other is a question whether it is in itself, if it is attributed to somebody, to some state. What is the nature of that allegedly international wrongful act? Is it a use of force, or is it a violation of sovereignty or territorial integrity, etc.? So I just want to know more clearly about your thinking.
First, in relation to attribution, may I briefly conclude, Your Excellency? Thank you.
The time is up. So if you want to summarize the answer to my question, you are free. I can give you 1 minute or 2, but otherwise, I think that concludes the presentation on the Riesland side.
If Your Excellency is satisfied, then this concludes Riesland submissions, Your Excellency. Thank you.
Thank you. Now, we have heard the presentations both by the applicant and the respondent, represented by 2 agents on both sides. There is still time allocated for the rebuttal by the applicant state and the 3rd rebuttal by the respondent state, if they are required. So I'm going to invite first the applicant state to make the rebuttal.
Your Excellencies, may it please the Court. Applicant raises 3 points on rebuttal. First, respondent's reliance on the case of EDF v. Bulgaria is misleading. In that case, the tribunal relied heavily on the Methanex v. United States award to deem evidence inadmissible. The award held that it was wrong for Methanex to introduce evidential materials that had been obtained by the same party. However, the obvious distinction between those cases and this one is that Estonia had no involvement whatsoever in the obtainment or the disclosure of the Frost files, and the Court of Justice of the European Union in the 2013 ruling on Persia International Bank held that the possibly unlawful nature of the disclosure of information cannot be held against the party seeking to introduce it as evidence when it had no involvement in the disclosure. Secondly, respondent has argued that the compromise is silent regarding the issuance of a warrant by the National Security Tribunal regarding Joseph Kafker. However, this special agreement submitted by the parties was negotiated by the two states, and while Margaret Mayer and the VOR employees were detained pursuant to a warrant and Friesland has agreed to this wording of the compromise, Kafker, according to the compromise, was only detained, and I quote, allegedly in accordance with the warrant, end of quote. Moreover, in the European Court of Human Rights case of last Thursday, Sabarov and others v. Bulgaria, the court found, and I quote, the absence of a written warrant cannot be described as a minor procedural omission, end of quote. Therefore, Friesland's actions amount to a violation of Article 9.1 of the ICCPR and do render Joseph Kafker's detention arbitrary. Finally, respondent has alleged that circumstantial evidence furnished by Estonia is insufficient to establish Friesland's responsibility. However, respondent has only referred to factual scenarios where IP addresses can be forged and malware code can be copied or stolen. Respondent has not provided any defensive evidence regarding the particular use of its own cyber infrastructure. Your Excellencies, the Eritrea-Ethiopia Claims Commission, in its partial award of 2004, found that the circumstantial evidence submitted by Eritrea shifted the burden of proof for non-attribution to Ethiopia, and because Ethiopia presented no defensive evidence, it had incurred in legal responsibility. Therefore, it is Estonia's contention that the circumstantial evidence is sufficient to establish prima facie Friesland's responsibility and to shift the burden of proof. If I can be of no further assistance, I will yield to a rebuttal. Thank you.
Thank you. That concludes the rebuttal, the argument in rebuttal by the applicant state. Now I call upon the agent of the respondent state for third rebuttal, if you wish to do that.
Thank you, Mr. President. First, the EDF v. Romania Tribunal explicitly distinguished this court's holding from Corfu Channel. And in that case, it was a journalist not affiliated with the claimant who illegally procured the evidence. Second, applicant misquotes the compromis. Paragraph 32 does not say that Mr. Kafker was obtained allegedly pursuant to a warrant. It says allegedly in accordance with the Terrorism Act. And indeed, the very same tribunal that would have issued a warrant reviewed his detention 3 days later. And finally, regarding shifting of the burden of proof, applicant's argument would be in direct contrast with this court's holding on another evidentiary matter in Corfu Channel, which was that the mere fact of the control of the evidence by one party, apart from other circumstances, does not shift the burden of proof. But in any event, in this case, respondent does not have total control of the evidence. For that, we ask this court to find that Friesland has complied with its human rights obligations and other obligations under international law. Thank you, Your Excellencies. May it please the court.
Thank you, the agent. Now that concludes the argument in rebuttal by the respondent's side. Now, that concludes the whole oral proceedings this afternoon between the state of Estonia and the Federal Republic of Friesland. Now, the court retires for deliberations, and in the meantime, I hope you have some other things to do. I have been informed at least that there are things which are being prepared to entertain you in the meantime while the judges are going to work. So the court is withdrawn. I give it to his bail.
The honorable court is now adjourned. Counsel and spectators will please remain in the courtroom to allow the judges to deliberate.
Please be seated. I offer my apologies. When I used to be the president, the please be seated was a common phrase that I used at the beginning of the session. Now I'm no longer the president of the International Court of Justice. I'm just sitting, waiting for the instruction coming from. Now, I'm going to make the announcement. First of all, of course, we have to apologize to the three judges for having kept you waiting in suspension, probably, in suspense. It's a good thing in the sense that it has taken such a long time for us to discuss all the merits and demerits of the different orators and the different teams. We must confess that by the way, I have been forewarned by the organizers of the Jessup Moot finals that judges should not talk too much about our own impressions about the individual performances, which is very appropriate because we don't do that in the International Court of Justice in real terms. So I'm not going to talk about the individual performance of the different teams and the different oralists. What I would like to say is that both sides have argued very well, and it was a very close match between the two. That is why it took such a long time. Nevertheless, it's our duty to decide, and after a long, quite constructive but heated discussion, we have come to the unanimous conclusion on the following. The team that we decided to be the winner of this final championship round is a team representing the amnesia.
One of the printers university.
Please be seated. I have still yet another function to perform, a very important function, equally important function to perform, which is to announce the best oralist in this final championship round. The three judges have come to, again, a unanimous decision that the best oralist in this final round this afternoon was the first agent of the team representing the Estonia.
can we find out who they are? And now can we find out who they are?
Close now, then.
Thanks.
Or not yet.
Runner-up trophy.
Okay. Okay.